Greetings everyone, I am Krati Rathi, currently a legal intern at ubAdvocate under the supreme guidance of Sir Gian Prakash, Advocate on Record, Supreme Court of India. Today I am going to deal with the concept of attempted suicide, that is a crime under section 309 of the Indian Penal Code of 1860. Now before exactly moving on to the concept, I would like to reveal some of the statistics to you related to suicide. Now, according to National Crime Bureau report, more than 1,30,000 people committed suicide in India. Out of them, more than 60% were literate and more than 10,000 of them were students. Now, India has recorded the highest suicidal cases in the Southeast Asian region. The major causes being depression, bankruptcy, marital affairs, chronic illness, loss of loved ones, failure in exams, etc. Now, suicide is an unnatural death with the intention to die originates within the person, and this particular intention has a reason behind it. Now, section 309 of the Indian Penal Code criminalizes attempted suicide and suicidal assistance. It says that whosoever tries to commit suicide or attempts to commit suicide or does any act in commission of such an offence shall be punished with simple imprisonment, which may extend to a period of 1 year, or fine, or both. Now, in the case of Gian Kaur versus State of Punjab, the Supreme Court held that the right to life is a natural life and also fundamental right which is guaranteed by the Indian Constitution under Article 21. However, suicide is an unnatural extinction of one's life, and hence it is incompatible with the concept of right to life under Article 21 of the Indian Constitution. On the other hand, the Bombay High Court declared section 309 unconstitutional in the case of Maruti Shri Pati Duval versus State of Maharashtra. It gave reference to the right to freedom of expression and thought. It said that the right of freedom of expression and thought also include the right of being quiet or silent. Similarly and logically, the right to life or right to live must also include the right to not to live. Similarly, in 2017, the Mental Health Care Act was passed, which decriminalized section 309 by restricting its application. It says that any person who tries or attempts to commit suicide shall be presumed, unless it is otherwise proved, to have done it because of severe stress, and such person shall not be tried under section 309 of the Indian Penal Code. Now, one thing to be noted here, that if it is proved that the person was not under severe stress, he can be tried under section 309 because it's still valid. Most of the Indian provisions, as you know, retain their British colonial legacy. But as a matter of fact, the British Parliament itself decriminalized this particular provision in 1961 by way of Suicide Act. The Law Commission has twice in 1971 and 2008 has recommended to repeal this particular provision of IPC. In March 2011, the Honorable Supreme Court as well recommended to the Parliament to consider deleting this particular provision from IPC. And recently in 2018, a Supreme Court bench, which was headed by Justice D.Y. Chandrachud, observed that it is inhuman to punish a person who has just failed from taking away his own life. Now, we need to shift from penalizing suicidal attempts and just focus on giving such people psychological or mental health care treatment, benefits, or support. And a demand for a reformative action stands still. And we need to consider, the Parliament of this country needs to consider repealing or striking down this particular provision of IPC, as it stands against the concept of social and natural justice to people. Thank you, and I would love to know your thoughts in the comments below.